Okay, part two of Subordinate Magistrates, Book 1, Chapter 9, Blackstones. Um, we're talking about the coroner and trying to figure out who he might be. So, in this light, the Lord Chief Justice, the King's Bench, is the principal coroner in the kingdom. Lord Chief Justice is the principal coroner. This officer of his equal antiquity with the sheriff. Okay? He is chosen by all freeholders. But there are also particular coroners for every county of England. Usually 4, but sometimes 6 or sometimes fewer. And I was just thinking, when I was looking at some county website in Michigan, it seemed like a couple of them had names or had something behind their name other than just who they were. But in one of the other books of Blackstone's, he says who these people of the King's Bench are. Right? That there's, I think he says there's the Chief Justice, and then there's 4, or there's some, what's the word I want to call them? Subordinate justices. They're not the chief, they're just justices. And then they each have kind of a name that goes with them. And one's like the elder, and I can't remember what the other ones are, but I have to go back and look. Okay, so that none but lawful and discreet knights should be chosen. Well, again, if they're a knight, they're, very few of them are knights. They're going to have the estate of inheritance, and to be a knight means that you're a sergeant at law. Sergeant at law means you're a master at the bench, I think. But it seems it is now sufficient if a man have lands enough to be made a knight, whereby he be really knighted or not. And there was an instance in somewhere that a man being removed from office because he was only a merchant. The coroner ought also to have estate sufficient to maintain the dignity of his office, and answers any fines that may be sent upon him for his misbehavior. And if he have not enough to answer, his fine shall be levied on the county as a punishment for electing an insufficient officer. Unbelievable. Now, indeed, though the culpable neglect of gentlemen of property, this office has suffered to fall into disrepute and get into low and indignant hands. Well, guess what they just said? That they're going to put the penalty on the county because we put inferior people in there. So that although formerly no coroner would condescend to be paid for serving his county, and they were by aforesaid statute expressly forbidden to take a reward under pain of great forfeiture to the king, if for many years past they have only desired to be chosen for the sake of their prerequisites, being allowed fees for their attendance by the statutes, Sir Edwin Colt complained heavily, though they have since his time been much enlarged. So he was complaining about what they got back in the day, and now we're saying it's even worse. And so that these people that fill the positions of these coroners, now this is, so although formerly no coroner would condescend to be paid for serving his county. So because the earls, right, they were gentlemen of the property, this office has suffered and fallen into disrepute and get into low and indigent hands. I don't know what indigent means. So the coroner is chosen for life, but may be removed either by being made sheriff or chosen vendor, which is the guy in the forest, which are also incompatible with the other, or by the king's writ discharging the coroner for a cause to be there and assigned, as that he is engaged in other business, is incapacitated by years or sickness, has not sufficient estate in the county, or lives in an inconvenient part of it, and by the statute, neglect, misbehavior, are also made cause for removal. So there's another writ for the king, discharging the coroner. That's just an order from the king. The office and power of the coroner are also, like those of a sheriff, either judicial or ministerial, but principally judicial. This is a great measure certain by statute, the office of coroner, and consists, first, with inquiring, when a person is slain or died suddenly or in prison, concerning the manner of his death. And this must be in view of the body, for the body not be found, the coroner cannot sit. He must also sit at every very place where the death happened, and his inquiry is made by a jury from 4, 5, or 6 of the neighboring towns, over whom he is to preside. If any be found guilty by this inquest of murder, he is to commit to prison for further trial, and also to inquire concerning their lands, goods, and chattels, which are forfeited thereby. But whether it be murder or not, he must inquire whether any deodand has accrued to the king, or the lord of the franchise, by this death, and must certify the whole of this inquisition in the court, the king's bench, or the next assize. And this assize, I think, is when this is like when the county commissioners get together. It's like a jury of 12 or 12 judges or something like that. Something else to go look at now. Another branch of his office is to inquire concerning shipwrecks, to certify whether wreck or not, whose possession of the goods, concerning treasure trove. He is also to inquire who are the finders, where it is, whether anyone be suspected of having found and concealed a treasure, and that may be well perceived when one lives riotously haunting taverns, and this it was done for a long time. Thereupon he might be attached and held so bail upon this suspicion only. And this has to do when somebody comes in, since your property is, your real estate is considered abandoned, right? Or your deed of trust may be considered abandoned. Some kind of property is considered abandoned. They say, hey, that's mine, I found it, right? But are they concealing a treasure? Do they really know who the owner is? And they're just saying they found it and they don't know who the owner is. Well, they have to put up bail when they bring these things to court, because the coroner has to decide. That's interesting. The coroner's going to decide who gets the treasure trove. So somebody conceals that they found this treasure, and you come back later and say, hey, that was my treasure. Here's my receipt. Here's my paperwork for it. Well, then they're going to have to go back and get it for you. The ministerial office of the coroner is only as the sheriff's substitute, for when such exception can be taken to the sheriff for suspicion or partiality, and that he is interested in the suit, or of kindred to either plaintiff or defendant, The process must then be awarded to the coroner instead of the sheriff for execution of the king's writs. Okay. So the next species of subordinate magistrates for whom I am to consider are justices of the peace, the principal of whom is the keeper of the records of the county. So whoever keeps the records of the county is the principal justice of the peace. Justices of the peace. The common law has ever had a special care and regard for conservation of the peace. For peace is the very end and foundation of civil society. And therefore, before the present Constitution of Justices was invented, there were peculiar officers appointed by common law for the maintenance of the public peace. So before the present Constitution of Justices were invented, in other words, first in line, first in time, this was before that, they had these people called justices of the peace. Of these, some had and still have this power annexed to other offices which they hold. Others had it merely by itself and were thence called keepers. Keepers of the peace. Those that are so by virtue of their office continue, but the later sort are superseded by the modern justices. So whoever is a justice by the modern justice. So justice, what do they call it? Sorry, I go back up here for my own sake. Hope I can find this again. The Lord Chief Justice. Okay, so that's what they call them. Now, where was I? Coroner. Present Constitution, Justice. Okay. So that the latter sort are superseded by the modern justices. So they are justices of the peace. The Lord Chief Justice is a justice of the peace. And there's other ones who were called the keepers of the peace. And they were around before the time of before the present Constitution of Justices. And they said at that time it was keeper of the records of the county. So that's the top justice of the peace. The keeper of the records of the county is the top justice of the peace. The King's Majesty is, by his office of dignity royal, the principal conservator of peace within all his dominion. Well, guess what? The king is the principal conservator of the peace. And he may give authority to any other to see the peace kept and to punish such as break it. Hence is usually called the king's peace. So, I demand the king's peace. The chancellor or keeper, the Lord Treasurer, the Lord High Steward, the Lord Marshal, the Lord High Constable, when any such officers are in being, so when they are in being, like when they're wearing that hat, and all justices of the court of the king's bench by virtue of their offices, and the master of the rolls by prescription, I wonder what that means, are general conservators of the peace throughout the whole kingdom, and may commit all breakers of it, or bind them in recognizance to keep it. The other judges are only so in their courts, in their own courts. The coroner is also conservator of the peace within his own county, as is also the sheriff. And both of them take a recognizance or security for the peace. So the coroner and the sheriff are both of them. And see, to me, so now we're talking the coroner and the sheriff are the two chief justices. You got one in the circuit court and you got one in the king's bench, or you know, he's either the guy in small claims court, and he is that would make him the chief justice of the king's bench, or he's over in the probate. And so if your probate court has 5 judges listed, justices listed, and one of them is the chief justice, then I'm going to say that's the guy they're talking about. But if you only have 4, or you don't have all of them in your county, then it's not necessarily the same person. It would be a different chief justice, and he could be over, he could be over the district court, because over the district court, they hear all the cases under 40 shillings. Yeah, well, another little puzzle to figure out. Those that were, without any office, simply and merely conservators of the peace, either claim that power by prescription, or were bound to exercise it by the tenure of their lands, or lastly were chosen by freeholders in full county court before the sheriff. The writ of their election directs them to be chosen from the most upright and powerful of the county as keepers of the peace. But when Queen Isabel, the wife of Edward II, had contrived to depose her husband by forced resignation of the crown, and had set up his son Edward III in his place, this being a thing then without example in England, it was feared would much alarm the people, especially as the old king was living, though hurried about from castle to castle till at last he met his untimely death. They finally caught up to him. To prevent therefore any rising or other disturbance of the peace, the new king sent writs to all sheriffs in England. So the new king sent writs to all sheriffs in England, sent pleas to all sheriffs in England, the form of which is preserved by Thomas Wolfingren, giving a plausible account of the manner of his attaining the crown, to wit, that it was done by his father's good pleasure, and withal commanding each sheriff that the peace be kept throughout his bailiwick on pain and peril of disinheritance and loss of life and limb. So, the former which is preserved by Thomas, and that has a link to it. I have to go down and see what that is. Giving plausible account of the manner of his obtaining the crown. This is how this dude did it. This is how he attained the crown. To wit, that it was done by his father's good pleasure. Right? Well, his father being the creator. In my opinion, that's who we are, right? The Father's given us the crown. We can be the rightful heirs of the kingdom of heaven. So I got to look up Thomas Walsingham and see what he did. Hope I can find it on the internet. And in a few weeks after the date of these writs, it was ordained in Parliament that, for the better maintaining and keeping the peace in every county, good men and lawful, which are no maintainers of evil, or barrators of the county, should be assigned to keep the peace. And in this manner, and upon this occasion, was an election of the conservators of the peace taken from the people and given to the king, this assignment being construed to be by the king's commission. But still they were called only conservators, wardens, or keepers of the peace, till the statute gave them the power of trying felonies, and then they acquired more honorable appellation of justices. Okay, so now we're back to all the shit that's happened. We're back to, at some point, they gave them the power of trying felons. And then they acquired the more honorable and honorarium appellation of justices. So we're back to Lord High Justice. Or the Chief Justice. These justices are appointed by the King's Special Commission under the Great Seal, the form of which was settled by the judges in 1590. This appoints them all, jointly and severally, to keep the peace, and any two or more of them to inquire of and determine felons and other misdemeanors, in which numbers some particular justices, or one of them, are directed to be always included, and no business to be done without their presence, the work of the commission running thus: of whom we will that some of you, A, B, C, D, etc., be one, whence the person so named is usually called justices of the quorum. Okay. Informally, it was customary to appoint only a select number of justices, eminent for their skill and discretion, to be of the quorum. But now the practice is to advance almost all of them to that dignity, naming them all over again in the quorum clause, except perhaps only some one inconsiderable person for the sake of, except perhaps only some one inconsiderable persons for the sake of propriety, and no exception is to be allowed for not expressing in the form of warrants, etc., that the justice who issued them is of the quorum. Okay, so now they're talking about, in my opinion, the notary, a notary public. Formerly, it was customary to appoint only a select number, right? But now the practice is to advance almost all of them to that dignity, naming them all over again in the quorum clause, except perhaps only some one inconsiderable person for the sake of propriety. Got to figure out what that means. And no exception is to be allowed for not expressing in the form of warrants, etc., that the justice who issued them is of the quorum. No exception is allowed for not expressing in the form of warrants that the justice who issued them is of the quorum. And what's the quorum? See, it sounds to me like the warrants have to come from the, I think the quorum is the county commissioners. All right. Well, figure it out. Touching the number of qualifications of these justices, it was ordained by statute that two of these, of the best reputation in each county, shall be assigned to be keepers of the peace. But these being found rather too few for the purpose, it's now provided by a statute that one lord and 3 or 4 of the most worthy men of the county, with some learned in the school, shall be made justices in every county. But afterwards, the number of justices, though the ambitions of private persons became too large, that it was thought necessary to restrain them to the first 6, and afterwards to 8 only. So, here's another one of these positions that over time has taken on many, many different many different attributes. By this rule, it is now disregarded, and the cause seems to be that the growing number of statute laws committed from time to time to the charge of justice of the peace have occasioned also, and very recently, their increase to a large number. So now we're back to a large number. And as to their qualifications, the statutes just cited direct them to be of the best reputation and most worthy men in the county. And the statute orders them to be the most sufficient knights, esquires, gentlemen of the law. Okay, so now we're back to you got to be a knight, an esquire, or gentleman of the law. They must reside in their several counties. And because, contrary to these statutes, men of small substance had crept into the commission, whose poverty made them both covetous and contemptible, it was enacted that no justice should be put in commission if he had no lands of value of 20 pounds per annum. And the rate of money being greatly altered since that time, it is now enacted that every justice, except as therein accepted, shall have 100 per annum, clear of all deductions. And if he acts without such qualifications, he shall forfeit the 100 pounds, which is almost equivalent of the 20 back in some other time. And of this qualification, the justice must now make oath. Also, it is provided no practicing attorney, solicitor, prosecutor shall be capable of acting as a justice of the peace. As the office of these justices is confirmed by the king, so it substitutes only during his pleasure and is determinable. By demise of the crown, that is 6 months after, express writ under great seal, discharging any particular person from being any longer a justice. So everything has to be done under great seal again. By superseding the commission of the writ, which suspends power of the justice, but does not totally destroy it. See, it may be revived again by another writ. Got all sorts of writs. But a new commission, which virtually, though silently, discharges all the former justices that are not included therein, for 2 commissions cannot subsist at once. By ascension of the office of sheriff or coroner, formerly it was thought that if a man was named to any commission of the peace, and afterwards a new dignity conferred upon him, that this determined his office, and he no longer answering the description of the commission. See, that sounds like commissioners. But now it is provided that notwithstanding a new title of dignity, the justice of whom it is conferred shall still continue a justice. The power, office, and duty of a justice of the peace depends on his commission and several statutes. So they can have different levels of powers depending on their commission. And I know that in Michigan that says the notary says where their commission is at, right? So they are a form of a justice of the peace, depends on their commission, and on the several statutes which have created objects of his jurisdiction. His commission first empowers him singly to conserve the peace, and thereby gives him the power of ancient conservators at common law in suppressing riots and affrays, and taking securities for the peace, and in apprehending and committing felons and other inferior criminals. It also empowers any 2 or more to hear and determine all felons and all offenses, which is ground for their jurisdiction at the session, of which more will be said in its proper place. And as the power given to 1, 2, or more justices by the several statutes, that from time to time have heaped upon them such infinite variety of business that care to undertake and fewer understand the office, there are such and so great importance to the public that the country is generally obliged to any worthy magistrate without sinister views of his own will engage in this troublesome service. And therefore, if a well-meaning justice makes any undersigned slip in his practice, great leniency and indulgence is shown to him in the courts of law. And there are many statutes made to protect him in upright discharge of his office, which among other privileges prohibits such justices from being sued for any oversight without notice beforehand, and stop all suits begun on tender made of sufficient amends. But on the other hand, any malicious or tyrannical abuse of their office is sure to be severely punished, and all persons who recover a verdict against a justice for any willful or malicious injury are entitled to double cost. It is impossible upon our present plan to enter minutely into particulars of accumulated authority thus committed to the charge of these magistrates. I must therefore refer myself at present to subsequent parts of these commentaries, as will in their turns comprise, in almost every object of the justice's jurisdiction, And in meantime, recommend the student perusal of Mr. Lombard's something or other and Dr. Burns' Justice of the Peace, wherein he will find everything relative to this subject. But in ancient modern practices collected, great care and accuracy in disposal of a clear judicial matter, but both in ancient and modern practice, collected in such care and accuracy and disposed in a most clear and judicious method. So Dr. Burns' Justice of the Peace and Mr. Lombard's something else. So that's as far as I'm going to go with this. I just wanted to go through those. It's already taken me too long to do this, and I'm tired of talking about it. But I'm going to go back and study it more. We'll see y'all later.